Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which has come to us from Oxford University Press, and it's a book which I find very interesting for those of you who are involved in practice as I am. The title of the book is Contributory Negligence in the 21st Century, and it's been written by two professors, James Goudkamp and Donal Nolan. Now, the book, as I say, is from OUP. Elizabeth and I talked about the book, and we've given a title for our review, the following: A Cornerstone of Private Law, How Contributory Negligence is Handled by the Courts. And let me say right at the beginning that this is an important area, and often for practitioners it's one that plays a much bigger role than we would normally expect it to do, because it looks at the behaviour not just of the defendant in an action in tort, but also the behaviour of the claimant. And that's something that quite often can have an effect, and it's something you should be well aware of when you're advising a client in conference. Let's have a look at the book first of all. It's a hardback. There it is there. Now, what I'm showing you is there's the actual book. It's not a particularly heavy book, but it's robust. There's the spine, and then there's some detail on the back. As I say, it's a hardback. There's nothing on the inside back dust sheet, and on the front dust sheet there's nothing there either, but that's just really to keep it nice and pristine. Now, it runs to 320 pages. You can see the index at the back there. It's actually indexed by paragraph numbering, and as is to be the case with OUP structured books, it has a particular structure of its own, very much the house style of OUP. Then there are in fact some cases listed at the back of the book. If we go to the front of the book, you can see here the front cover, and then after that you can see the blurb from OUP. There is a dedication, and I'm just going to show it to you. I'm not going to say anything more. A lot of people are involved in the production of books. Our policy here at Richmond Green Chambers is we do not review books that we don't think very much of. There's no point, because in fact the people who put the work in should not be treated really badly, in my view, with a very critical review. So the purpose behind the reviews is to show people what the book is for, in case it's something you need for your practice. The preface is very useful. It sets the scene very well from the two authors, and is dated the 3rd of September 2018. I'm recording this review in the summer of 2019. You can see the list of chapter headings and the 4 appendices. There are 9 chapters, an introduction and a conclusion, and it's looking basically at the law of contributory negligence, methodology, then looking at contributory negligence, first instance, appeal, on the roads, at work, the professions, and then a conclusion. So it gives you a fairly broad picture of the law of tort and how it works. Then you've got a detailed contents section. I like the way they do that, actually. I think it works very nicely with OUP titles. Then there's some figure work, and actually listed there with tables. Then you've got the cases, lots of cases in this particular area. Then after that you've got some overseas cases. You can probably see those, Canada and Ireland and so forth. Table of legislation, a limited amount of course, because there is the statutory basis of the law. Then you've got the book itself, chapter 1, you've got the introduction, you can see how it's structured, the paragraph numbering is at the sides, and you've got the footnoting at the bottom. This basically runs all the way through. You can see there's quite a liberal use of tables and charts and so forth. I'll put that there. Now, what do we say about the book? Elizabeth was the lead writer on this particular review. To the surprise of some people, contributory negligence is a doctrine that all too often emerges as a key issue in all too many cases. And as I indicated in my opening remarks, one of the problems is we quite often don't put as much emphasis as we might do with the client in this area. And as such, therefore, it's referred to as a cornerstone of private law by the authors James Goudkamp and Donal Nolan. And it's a new title, of course, from OUP, Oxford University Press. It seems almost paradoxical that despite its centrality, little is known, say the lawyers, almost little that is, about how contributory negligence functions in reality, specifically the ways in which it's handled by the courts. And I would agree with that as a practitioner, in that quite often it's an area which is always there in the background, and it's something I would suggest would be certainly something you might like to weigh up if you're trying to negotiate your way out of a piece of litigation. It's a research-based book, this one. It's information-rich as an exposition, and therefore it explores the when, why and how of the ways in which contributory negligence can or cannot be used as, for example, a significant mitigating factor in a range of cases, the majority of which involve settlements of claims. And I think that's an important point to bear in mind in view of the formal mandatory mediation policies that we are going to face in 2020, where a lot of these cases will be mediated first, even with the pre-action protocols, prior to actually being heard as a trial in the courts. Now, as the authors point out, the doctrine of contributory negligence reduces the compensation that a victim of a wrong receives where the victim was partly to blame for his or her own damage. Where claimants have turned out to be the authors of their own misfortune, such as not wearing a seatbelt or getting drunk, that's just to name a couple of mundane examples, the compensatory sums they claim can be reduced. Now, obviously that, as I say, is part and parcel of the claim and then the defence and what will be put forward as contributory negligence in the defence. Because if it's contributory negligence, it doesn't act as a claim in its own right, of course, but what it does do is it points out that the other side are partly responsible, and therefore when it comes to quantum, the money should be reduced. The authors go on to say that contributory negligence can exert a powerful effect on the quantum of recovery, as I've indicated, often in litigation and in negotiated settlements. And clearly the policy at the moment of the Ministry of Justice, which makes sense certainly to me as a practitioner, is to try to limit the number of cases to the very serious ones and see where, if at all possible, one can mediate and get a structured agreement. In other words, a memorandum of accord or something like that. Also, of course, another point that should be borne in mind is the claimant can be left with uninsured losses, particularly in cases of personal injury. That should be borne in mind. Now, in discussing the central features of the law governing contributory negligence, the authors focus on the key initial point, namely that contributory negligence must be pleaded by the defendant. In other words, when it's his chance to put forward his defence, he must state that. Whether the claimant is actually liable for contributory negligence can be determined, of course, by the judge on the facts in the first stage of the process. The second stage basically involves the judge apportioning responsibility for the damage between the parties in accordance with what is just and equitable, as basically a sensible judicial test. Also, of course, the defendant must show that the claimant had failed to take reasonable care of his or her own safety or interest. In other words, you've got a mirror image of the basic principle of the law of negligence, which is the duty of care which is breached and then consequent damage and causation. Now, interestingly, the authors researched a total of 701 decisions handed down by the courts from the period between the year 2000 and 2016 in all parts of the United Kingdom. And it was with a view to determining how often a defendant's plea of contributory negligence was successful and the amount by which a claimant's damages were subsequently reduced. Variables such as age, gender, type of damage, etc. were also considered. And I think that again is useful because when you're looking at the totality of a case and what we call a reality test of what's really going to happen, I think it's very important to get very down to earth as to where the case will be going. Now, the authors are both from the University of Oxford, and they've made an important contribution to the literature on this subject, and therefore I would dare say they are leaders in the field. And it's a detailed, of course, investigation we have here of the everyday practicalities, which oddly enough have hitherto been largely unexplored in the past. And so I'm very grateful that they've set the record straight. The hope is expressed that this study will be used to inform future developments in what's an often vexed area of law. Now, as I say, it can be vexed in the sense that obviously it is very much a question of identifying that there may be contributory negligence, making sure you've pleaded it, and then having the argument. And obviously you can use that as a tool in the negotiation process. And frankly, a lot of cases do settle once it becomes very clear that there is clearly an element of contributory negligence in the case. Now, obviously, some people won't bother listening to anything we give them by way of advice, and you go ahead, and then the judge will have to make the final orders on quantum. But if sense prevails, you can see the logic of getting a settlement. Let me conclude by saying that lawyers, academics, and certainly members of the judiciary, we think, will no doubt regard this book as essential reading. We certainly have as practitioners. The extensive tables of cases, of claims data, etc., detailed in the book's 4 appendices, are well nigh indispensable. The only word of warning I would give is that one of the problems is you've got to keep up to date. Now, when you're dealing with something like this area, do keep in mind current law published by Sweet and Maxwell as well, because that will give you the very up-to-date case law. Whereas this book is current now for 2019, the date of publication is 2019. I think it's very important to bear in mind the fact that before we know where we are, a few years elapse and then the cases will become a little bit older. I'd like to thank everybody concerned for the production of this book, OUP in particular. There's the front again, the spine and the back. And if I just open it in the middle, you can see there's some tables of cases. There are lots of cases all the way through, nicely set out with the citation and all the various details, the courts, and then the claims and all the various matters. Very, very much, in fact, in the way that current law sets out a number of the cases as well. And of course, what we have right at the back, which I do find, there's a matter concerning professionals, and then right at the back, you do have a quite useful short conclusion section, which brings the law where it is at the moment relatively up to date. Because, as I said in the opening, the position about contributory negligence is relatively new. When I first started reading law, it had only been on the statute book for 20 odd years. And now that's 50 years ago. So you can see there's a very substantial change in the way we do things. The courts are different, of course, as well. And I think probably the expectations of the claimants have changed. One of the problems, of course, is that the courts in this country are notoriously mean when it comes to quantum. So you're not going to get a great deal of money. And the costs, of course, can quite easily outstrip whatever it is you're seeking, especially in specific areas of case law, which would be perhaps road traffic matters and so forth. Anyway, they thank you very much to Professors Goudkamp and Nolan for this work, and I hope you find it helpful in your practice. Thank you. Bye-bye.